Yu. She's now a very well-known corporate figure, as well as I think our ambassador to several countries. Back in her younger days, Pang Qinglian was a stringer for Newsweek, and she filed a newspaper. She filed a series of newspaper articles, right, which suggested that the courts were not independent, and she was punished for contempt of court, right? Same thing with Wong Hong Toy and Fred Zimmerman. I won't go into them, some cases. Among the bloggers, I think the one that you all may be familiar with is a chap called Gopalan Nair, former lawyer, former member of the, I think, Workers' Party, who came to Singapore to apparently wind up his own business, and then got arrested and was put on trial for the blogs that he his blog sites or blogs. His blogs were pretty insulting. I think he apologized. He was jailed, I think, for 5 months, and then after that he packed up, went back to the US, and then everything back to normal again. So if you go back and you go and blog, Google Gopalan Nair and his blog, you find all the same incendiary stuff that he had put up earlier, right? Really quite amusing reading. You can have contempt of court by wearing the wrong type of t-shirt as well. Alright? This is the kangaroo court case where the 3 people put on these shirts, t-shirts with kangaroos in judges' robes, right? Yes, Pang Qinglian's case, she provided information for an article called Singapore Selective Justice. The High Court said that she did little to dispel the notion that the courts here are little more than extensions of the one-party system. In the courts in Singapore, the offending words were, it makes a vital difference whether it is the government or the opposition that is in the dock. This was the offending provision that says that, well, if you start saying things like that, then obviously people do not believe in the fairness of the system. This is Pang Qinglian. Right? I got 2 of these slides, sorry. Fred Zimmerman article, published an article called Jayaranam's Challenge in the Asian Wall Street Journal. It suggested that the courts were not independent. Public had little faith in its independence. Who were sued? Not only the owners of the Asian Wall Street Journal, the features editor, the publisher, editor, editorial page editor, the printer, and the distributor were all sued for, were all charged with contempt of court, right? Kangaroo court case. 3 members of SDP wore t-shirts imprinted images of kangaroo in a judge's robe. They sat in the public gallery in the Supreme Court for 2 days during the SDP defamation hearing, and one of them even said to Lee Kuan Yew as he was passing by, "This is a kangaroo court." They were jailed for 15 days. Obviously, the joker who said that this is a kangaroo court got 15 days. The other 2 got 8 days each for this contempt of court. Gopalan Nair. He attacked Justice Belinda Ang, seen in this picture here, for her handling of the SDP defamation case, and these were words that were used. The judge, Belinda Ang, was throughout prostituting herself during the entire proceedings by being nothing more than an employee of Mr. Lee Kuan Yew and his son and carrying out their orders. Got 8 weeks jail for that. Then he sent an email to Justice Lai Siu Chu. Your judge, Lai Siu Chu, has no shame. The reason why she and her fellow judges punish and silence PAP critics are because judges are well paid and have comfortable lives. They are selling their souls and their conscience for money. They are misusing the law for personal gain. Your Singapore judges, including Lai, are corrupt judges. Oh, this is asking for it. Right, so be careful with that. What is the test being used for contempt of court? Sorry, the slide not very clear here. The test is what they call an inherent tendency test. If there is an inherent tendency to cause people to lose confidence, in other words, I don't have to show that people have actually lost confidence. I just have to show that people are likely to lose confidence, are inherently likely to. Right now, this is like preempting several times over, you know, right? Let us look at a couple of cases. Barry Wang's case, again, Wall Street Journal, Asian Wall Street Journal, suggested that the Singapore judiciary was biased in the defamation case between Lee Kuan Yew and Far Eastern Economic Review. The court had clearly rejected the real likelihood. In other words, they say, no, we do not want to go down that route, right? In other words, the test should not be, does it have a real likelihood of putting into people's mind a negative perspective of the judiciary or people losing confidence in it. Real likelihood is too high a test. We adopt inherent tendency, right? This was affirmed in cases like Herzberg, mentioned to you just now. One problem is there is no defense of fair comment. You can't say that because I see this, this, and this, I think that you're not fair. It's strict liability, okay? And the statement of the courts here, it is settled law that any publication which alleges bias, lack of impartiality, impropriety, or any wrongdoing concerning a judge in the exercise of his judicial function, which has terminated, is contempt of court. It is sufficient to prove that the words complained have the inherent tendency to interfere with the administration of justice. The court further added why they thought the test was good. The inherent tendency test has two clear advantages. First, it does not call for detailed proof of what in many instances will be unprovable, namely, that public confidence in the administration of justice really was impaired by the relevant publication. Second, it enables the court to step in before the damage, i.e., the impairment of public confidence in the administration of justice actually occurs. Now, you can imagine the difficulty with this kind of a test, because even if it's true that the judiciary is corrupt, you can't say it. Now think about it, even if it is true, right? The words of Justice Sinnathuray in AG and Barry Wang. I recognize that this court has a duty to uphold the right of freedom of speech and expression. They always say that now. And I accept that this must be balanced against the needs of administration of justice, one of which is to protect the integrity of the courts. Right? The question here is, will suppression of criticism against judiciary inspire greater public confidence? I think this is a question from, since the whole notion of contempt of court comes from public policy, right? It is based purely on public policy to prevent people from, yeah.
Is this only in Singapore or is it worldwide in all countries?
No. This particular position.
I mean, this position that you can be punished for direct attacks on the courts.
Singapore is particularly archaic in the way we run this. As I will show you in one of the next slides, we are particularly archaic. Okay, there you see, it's very archaic. Now, the position came from a case called MacLeod and St. Aubin, Privy Council, 1899. And the reason why they adopted this inherent tendency test, right, on what they call, this is called scandalizing the court, scandalizing judiciary. It reads as follows: committals for contempt of court by scandalizing the court itself have become obsolete in this country. Just talking about England. It's become obsolete in England in 1899. Courts are satisfied to leave public opinion attacks or comments derogatory or scandalous to them. You know, we're bigger than that. But it must be considered that in small colonies, consisting principally of coloured populations, the enforcement in proper cases of committal for contempt of court for attacks on the court may be absolutely necessary to preserve in such a community the dignity of and respect for the courts. Absolute English arrogance. But repeated again and again
and a